So, from start with, the NDC minority went to Parliament seeking to shoot down, the exclusion of the current voters' ID card from the new registration that will go on in the CI 91 that is being made. Unfortunately, irrespective of how brilliant the arguments of Mahama Yarga were, as admitted by some of the majority members, they lost by a majority vote. And so the CI will come into being, and the new voters, the current existing voters' ID card will not be used. Now the court says it wants a justification, legal justification why it should be excluded. What exactly is the court expecting of the EC?
The court is asking the EC, obviously, to respond to the application that has been brought before it, of the legal circumstances that warrant the exclusion, the legal basis that explains or authorizes them to exclude it. You put this in legal context. Article 42 of the Constitution is the benchmark provision. Article 42 of the Constitution states that every citizen of Ghana who's above 18 years old and is of sound mind is entitled to be registered as a voter.
And to vote.
So that is and to vote. And so that is the primary premise of everything. And the court, in asking the EC to present the legal basis, I think, is obviously asking the EC to explain why, first of all, whether Article 42 has been complied with, and why and how, within the context of that provision, a rejection or exclusion of the voter's card, which is an issue, would not amount to a violation of the intendment of the provision of Article 42. If you read 42 together with Article 45, what the Constitution does is, first of all, to say that a person needs to establish three things in order to be a voter in Ghana. And when the person meets the three standard criteria, the person's name is entitled to be entered on the voters register, which is created under Article 45. So Article 45 deals with the voters register, which is created. But the voters register is created pursuant to Article 42. Now, Article 42, as I indicated, requires three things. The first one is that you must be a citizen. Now, I dare say that invariably that appears to be the difficulty often, establishing that one is a citizen. And I think we all know that we've not taken this issue of citizenship seriously over the years. And the coming of age of the Ghana card is a welcome development. There must be some standard document that differentiates who a Ghanaian is from who a Ghanaian is not. But in the meantime, any modality for establishing citizenship, once a person establishes that he's a citizen of Ghana, that person qualifies under the citizenship criterion established under Article 42. Once the person passes the test of citizenship under 42, the only two things the person has to establish, which in my opinion are less complicated, are whether the person is 18 years old and above, and finally, whether the person is of sound mind, even though I dare say the last one is equally as complicated in some circumstances. But fortunately, that hasn't presented much of a difficulty over the years. So the truth of the matter is that the court is asking the EC, it appears to me in the circumstances, to provide reasoned legal justification that explains the exclusion of the Ghana card in this circumstance. Now, let's unpack the discussion. It seems to me that there's confusion so much, which is ongoing, centers around three things. So we have to distinguish between what is legal from what is pragmatic, from what is feasible. What is legal allows you the legal authority to do what you have to do. And I'm not going to pronounce on this, strictly speaking, because there's a matter before the Supreme Court. But the question of what is legal is a question that answers the issue whether an action or a decision by a body is legally authorized. Whether the Electoral Commission has the right to compile voters' register is not in dispute under Article 45. Whether the Electoral Commission has the right to compile voters' register more than once in its lifetime, that is the issue before the court. Also, it seems to me. Therefore, and that explains why I'm not going to go into the context of that. But the compilation of the voters' register itself is not in dispute. The Electoral Commission has the right to compile a voters' register. Does the Electoral Commission have the right to compile a voters' register more than once in its lifetime? That is complicated. Now, if you look at Article 45, it speaks of the compilation of the voters' register, and then it goes ahead to speak of the revision of the voters' register. It seems to me that the contest before the Supreme Court doesn't focus on the revision at all. It seems that all parties agree that revisions can happen periodically from time to time. What I think is in dispute is the question of whether the EC, having compiled the voters' register since its establishment, can compile a new voters' register. And as I indicated, I will not prejudge the issue because this is a public discussion. I'm sure we'll come back to it sometime when the opportunity arises. But the next point is the question of pragmatism.
No, hold on. You spoke about revision, compilation and revision. In your reference to Article 45, the need to read 42 together with 45. How
Correct.
about 42 together with 45E, which appears to be the major contention, if you like, which says the EC can undertake programs for the expansion of the registration of voters. Expansion. That appears to bring up a question of whether the usage of expansion means it could do anything with the existing register other than expanding upon it.
Most respectfully, I do not think, and again, you are really tempting me to go into the discussion, something I'm doing my best to avoid. The Supreme Court is going to take a bite at this. The essential contest, which is before the court, centers around 45, which, and again, the E is also under 45, but centers around the question of compilation. And then revision is a minor issue. Expansion, again, from a pure linguistic perspective, speaks of increases or increments. So when you speak of expanding something, you're speaking of the existence of that thing, first of all. And then you're speaking of the growth or increment, elongation, etc., whatever it is you want to, however it is you want to describe it. But that still doesn't touch the central question of whether it can compile a voters' register. Compilation is composition.
So the legal justification required, can it include reasons that are factual about problems with the register? So if I can point to, and we have heard people suggest somewhere in K2 or somewhere, that there was some problem with the register and so it was bloated. So if I can suggest that these are ghost names, or they are whoever they are who are on the register wrongly, and therefore if I want to do a new register, you don't expect me to contaminate the new one with what is poisoned.
The basis for excusing an action when requested by the Supreme Court are normally of two kinds. We have factual basis and we have legal basis. When the court requests you to provide a legal basis for doing something, you are supposed to provide legal basis, not necessarily factual basis. Now, it's imperative, and I hasten to point this out, that because of the interpretive criterion that the Supreme Court usually applies, which is called the purposive approach, by which the courts interprets decisions, by which the court interprets the laws of Ghana, by looking at the fundamental purposes of doing things. The court sometimes goes beyond the pure legalistic facial interpretation of the laws and looks at the factual, not just factual circumstances, but the purposes underlying or undergirding particular laws. So in providing the legal justification, invariably, the EC, I'm sure, may provide things that are mixed legal and factual, or some of them which are even purely factual. Now, in so doing, of course, whoever is providing that, the intention behind that will be to ensure that it gives the court sufficient factual basis so that in its interpretation of the purpose, so the purpose here is the purpose behind the law, that is the legal, in its interpretation of the legal, it is aided by factual circumstances that informed the decision of adopting the particular provision in the Constitution in the first place. So the point I'm just trying to make is that ultimately, the court will be looking at whether or not a decision taken by the EC, a decision taken by whoever is involved, the body that's involved in circumstances, whether that decision doesn't violate Article 42.
Okay.
Article 42 is a very simple provision structured in a very simple way, but it's very loaded. Now, it's imperative to know that Article 42, as I mentioned the last time on this conversation, is perhaps the only human rights that is actually taken out of Chapter 5. Now, there's a purpose to that. The purpose is to stress the importance, the fundamental importance and the sanctity of the provision, i.e., in a manner not to make it violable.
Right.
So, in depriving anybody of the right to vote, we need to establish that that person himself may have contributed to the deprivation, but that the person was not deprived of the right merely because a particular logistical arrangement is not working or didn't work, or merely because we put in place a machinery that makes it difficult or impossible for the person to access the right. So if you look at 42, it speaks of a person qualifying, and then it says the person is entitled to register and to vote.
In fact, this same Supreme Court, has pronounced, just as you said, that even though you don't find the article in the human rights chapter, it is a human right. So please proceed.
Correct. Thank you very much. So that's absolutely correct. So as I mentioned, that's the legal part. Then the pragmatic part. The pragmatic part is something that may also then feed into the factual basis that you were speaking about when they're speaking and they try doing mixed facts and law. So you can provide legal basis, but then you can present mixed legal and factual, even though the legal has to dominate. But then the pragmatism. And again, the difficulty, I think, as I can tell from all the conversation, the difficulty that appears to confront the ongoing exercise or may confront the ongoing exercise is the circumstances of the time. I think the circumstances of the time makes a lot of things quite difficult. I think when the EC started speaking of this project some time ago, I didn't have much of an issue. I mean, of course, apart from the legal issue, which remains unanswered in circumstances, but I didn't have much of an issue because the credibility of the voters register is important to all. Now, the forensic credibility of the voters register is even more important to all. And if you are introducing a biometric register, you are fundamentally reinforcing the forensic character of the register, which is a very important thing. When you introduce forensic aspects of these things, nobody can challenge them. So the biometric register is a fantastic idea. But if you look at that within the context of the circumstances of the time, again, this is something that would present a challenge or a difficulty to whoever is answering this question as to whether we have sufficient time, as to whether the circumstances of the time permits that, the disease condition.
But the argument you would have heard, particularly from the NPP's perspective, includes that, as I mentioned earlier, we have known Afarijan to admit that this register is problematic. Now, even before the election challenge that was mounted, we know that, and Bright has so eloquently canvassed the position as held in the Abu Ramadan, Evans Nemako, and Kwesi Danso case against the EC, in which the court's argument was that, position was that, don't do a cleanup that affects everybody. Let's look for those that are infected and remove them from the register.
Because it's an individual right, not a collective right.
Yes, because it's an individual right and not a collective right. So the EC presented a number of persons that can be removed because they went through a process the court had declared as, invalid, using the NHIS card. The NPP is showing that The EC then lied to the court as regards the numbers of persons that needed to be removed, and therefore the register remains tainted with some of those people still on that register. So what's the point here? Are they not able to canvass this point as a more important point than just a legal justification?
Well, as I indicated to you, sometimes it's very difficult to provide purely legal justification or legal basis for taking a decision. Matters that the court itself may have made pronouncements on constitutes what is called matters that have attracted judicial notice. So the court itself is aware of these issues because they were made pursuant to a particular matter that came before the court. Now, it's imperative for us to also understand that as the court is asking the EC to provide a basis for the rejection of a particular card, the court invariably is interested in dealing with the difficulties presented by that card in terms of authenticity, in terms of duplicity, in terms of whether the cards involved may have been sufficiently mixed with other cards that you can't even differentiate which one which one actually has the proper authority of the state. So to the point that people presenting themselves to vote, we may not be able to validate the 3 criteria established under Article 42. Remember, I said these 3 criteria. The first one is the issue of citizenship. You must demonstrate citizenship. So a good legal basis by the EC, for example, will be to demonstrate that the card involved is of such sufficient tainted character that it undermines the principle of citizenship required under Article 42. So anyone presenting that card cannot be validated in terms of whether the person is a citizen and qualifies under the first leg for purposes of voting. The difficulty with this, of course, will be to show that there has been an audit conducted, and that audit has established some of the things that I mentioned. In the absence of this, you obviously will have a difficulty. But the key legal reasoning that the EC will have to show here is the legal authority. The legal authority to compile a register more than once in its lifetime. That is a key legal authority. If it has the legal authority to compile a register more than once in its lifetime, then the subsidiary legal authority will be the issue of the exercise of administrative discretion, i.e., you have the authority. How do you exercise the authority? You have the authority. Why have you chosen to exercise the authority in the circumstances of what we have at the moment? And whether there are alternative means that could have been explored, and these alternative means could have equally achieved the objective without having to exercise the discretion the way you are. But once you demonstrate that you have the authority, the only subsidiary difficulty or legal objection that could be raised by any other body or the court itself is the question of whether you have exercised the discretionary authority vested in you under Article 23 and 296 properly. And that's another challenge that could come in the course of the entire proceedings. So, as I indicated, the current situation we have is one that divides into these 3, i.e., do you have the legal authority? And if you have the legal authority, then the mixed fact and law, the question of pragmatism and the feasibility, whether or not in the circumstances of what we have, whether you have exercised your discretion in a manner that conforms to pragmatic considerations, and whether this is feasible, and ultimately in a manner that will not disenfranchise anyone under Article 42. Because Article 42 says once the person presents himself and the person qualifies under these 3 legs, the person must be accommodated in any registration mechanism.
Right. The other issue that some have raised is about the fact that our borders remain shut. Citizens are stranded abroad, and those who live abroad and would have wished to come register are unable to do so. Again, well, I prosecuted the ROPA case, and the court gave a time for the EC to implement the ROPA, register Ghanaians wherever they live, and to have them register wherever they are. The EC was unable to meet it, and therefore subsequently sought an extension of time. They were giving extension to do it now. It doesn't appear that they are able to implement ROPA 2 now. Question is, will there be constitutional matters? That's what people are asking about a person's right to vote being infringed, particularly when you look at it from the same court's pronouncement in the Tenade case. If you look at a pronouncement by the court such as, quote, a citizen's constitutional right to vote is so important that it can hardly be infringed and justified simply because a majority of the people, let alone some institution or organs, chose or agreed among themselves that it be. Neither the Electoral Commission itself nor in collaboration with Interparty Advisory Committee, IPAC, or any other authority can issue a directive which disenfranchises a citizen of this country. The Electoral Commission has no power to make any regulations which unnecessarily abridge the right to vote. Whatever it does in this direction should rather facilitate the exercise of the right to vote.
Correct. The court has repeatedly, and you have mentioned all the cases, including Tenadi, so there's no need to go back on them. But the court has, in many cases, repeated the imperative of ensuring that facilitations and facilitative options are put in place in a manner as not to disenfranchise anyone. People must be allowed, people must be facilitated towards the exercise of the authority and not and not put in place mechanisms that actually are obstructive. And that's why the feasibility and pragmatism making comes into being. At the same time, if you're on the EC side, your argument, among others, will be that you have to facilitate the process for people to vote. But facilitation doesn't mean that you should allow people who are not qualified. The facilitation should be for people who are qualified, people who come under the 3 standard criteria established under Article 42. And in so doing, the EC says we'll put in place these mechanisms, including the proposed forensic mechanism, to ensure that the register is good for all time moving forward. But balancing the two is not exactly easy, and there are tensions. Of course, for political parties who are uncertain of the entire process, parties look at these things from different perspectives than lawyers would. Or let's say the political consideration is different from the legal consideration. For the political consideration, you are very worried about practical or implied gerrymandering tactics. Tactics and strategies that result in weakening of your voter base, so that you have exercises being more successful in areas which are stronger than, which are stronger against you, and therefore your strong base, as one of the parties was complaining, is actually being disenfranchised in a manner that you're not happy with. So for the parties, the consideration is not necessarily the legal, but whether or not the political circumstances or variables are actually in their favor. And that's why it's imperative that the EC also deals or bolsters the issue of the integrity, not only the integrity of the proposed database, but the integrity of the current database. Now, the strategy of the Constitution in ensuring that the current database remain up to date and is of relevant data is the mechanism of revision, i.e. that the EC is allowed to revise the voters register from time to time. Revision involves removal, revision involves addition. Revision is a general cleanup. So if revision is properly done, you can actually use the mechanism of revision to achieve the tactic or strategy of compilation. The difficulty with this is that the EC wants not only just a revision, but it wants a forensic revision, if you like, a revision that is of a character that cannot be impeached, and that is of a character that cannot be interfered with in a negative manner moving forward. So these are the tensions, and that's what I'm saying. The central question will be whether the EC can go beyond revision to compilation, which you then raise the question whether the EC can compile the voters register more than once in its lifetime. And Article 45 is the relevant provision that deals with this, and it's interesting to hear the argument.
So once we are still on the Constitution and these 2 articles, I'll ask my last question to you before we take a break and return to hear the 2 of you a lot more on this issue. In the 10-day matter, you remember that Justice Akwa made the very emphatic statement that we lawyers have used over time when he said that the explanation to Article 42 is that you just are 18 and or above and you are sane, you are sound mind. Once you have that, it says, they said the voting that the right to vote is indispensable and that it cannot be denied in the absence of a constitutional provision. It cannot be denied in the absence of constitutional provision. Question is, in the COVID times, if somebody was receiving treatment, if somebody was in isolation, and you have come to their area to register within the period, and so on and so forth, having coronavirus is not the same as having an unsound mind. So you cannot use that to deny them the right to vote. Is that not so? Those who are being checked before they register, for example, if it is found out that your temperature is very high, are you going to be turned away? Is the EC able to do that once they are using all the COVID-19 protocols in the registration?
Well, again, very complicated questions, but the Constitution clearly recognizes the need to balance rights. And so the Constitution allows suspensory rights on the part of the executive for the exercise of certain rights in the interest of public health. Once these are done properly, according to the requisite legislative instruments or executive instruments, if you look, for example, the provisions under Article 31, the emergency powers, there are certain, powers that can be exercised by the president, pursuant to emergency situations in Ghana, and the current regime under which executive instruments have been issued, that is also allowed. So there are a few circumstances under which you can have certain rights suspended, pursuant to public health, among others. So the fact that you have the right to vote will, of necessity, not imply a violation if that right is suspended for clear public health situations.
The court said it cannot be denied unless there is a constitutional provision permitting the denial. Constitutional provision, not an EI or an act.
No. My understanding of that is not. My understanding of that doesn't coincide with what you're saying. My understanding of that is unless there's a constitutional provision, and the constitutional provision is what I've just mentioned to you.
Okay.
If you look under Article 21, if you look under Article 31, there are what lawyers will call clawback clauses. These clawback clauses allow some clawing back of human rights under some circumstances. I'm being very careful on this because I'm not a big fan of clawback clauses. People should have the right and they should exercise the right. But under some limited circumstances and justifications, if it is established that a person has a public health situation which makes him a natural danger to third parties, and the person is under controlled environments or circumstances, and it's almost difficult or impossible to exercise the right in the context in which it is, that would have been discretionary authority exercised under that constitutional clawback clause through an executive instrument, which in my opinion would be legitimate. But, as I said, this is a difficult situation. I hope we don't really have to get there. But where it is justified and where very clear, justifiable basis can be provided for that. The fact that none of the rights in the Constitution is absolute. So when Justice Alka was saying that, what he was trying to say is that the right to vote under Article 42 is almost equivalent to the right to life under Article 13. The two are inviolable. You can't violate them. They are human rights that have to be exercised nearly at all times. But when he said that, obviously at the back of his mind, subject to reasonable limitations, justifiable limitations in peculiar times. And I think this is one of the peculiar times. But of course, you must have demonstrated.
Tenade was one single individual. And he got us to a standstill for the court to, vindicate his rights. We had we had assembly elections that were held, that were botched really by one person, one individual. The fear by some is that you may proceed with a process, and that process, the results of that process may now become a subject of, litigation that may ruin the whole exercise.
It's imperative that we recap the electoral architecture of Ghana. And the electoral architecture of Ghana, as I have followed so far to this point, is one that tries to adopt an inclusive approach. The inclusive approach is designed to avoid or avert the truncation of the process through parties who may be aggrieved. The inclusive approach is designed to ensure that parties' concerns and grievances are taken into account and that they are dealt with along the line. I think any attempt to go the legalistic way can be problematic, and the legalistic way being that the EC saying, these are my legal authorities, I'm exercising them. And then third parties saying, we will exercise remedial options. And that remedial option could be going to court on the eve of the election and securing an injunction, and then putting the entire electoral process in jeopardy. So there are all kinds of legal mechanisms and mechanics that can undermine the prospect of the election for this year. And we should all do our possible best to avoid that. The only way to avoid that is to ensure a process of inclusivity, a process that takes people into account, the stakeholders. If you look at, the bodies that we have the peace bodies, that is the peace, led by the Peace Council. We have all kinds of CSOs, including CODEO. We have the political parties, the Interparty Advisory Committee, and all that. We have all these bodies that act and speak to each other together with the EC as a key player, as a central referee in all these. We have all these parties that talk together. I think any tendency to go the legalese way or the legalistic way is likely to result in a cataclysm, and that cataclysm can undermine everything that we have. Because anybody can go to court on the 6th of January and secure an injunction. And 6th of December and get an injunction. That can put everything in jeopardy, and then we're in trouble. And I hope that we don't have to get.
All right, we'll take a break here. We'll return and continue with this discussion because it's the only issue we have to continue to discuss. And Bright Simmons is still here. We'll be right back. We'll take the concluding comment from Dina Bochi. What would you like to say in the end? There are people who are saying that it does appear there should be some room still, like you have also suggested, for some consultation and things. The National House of Chiefs, for example, appears to have, giving an invitation, which we understand is being declined by the Electoral Commission, among others. The EC2 must do its work. So it seems to be proceeding, that it is setting that it's doing what is right, and that's the job it's giving to do.
I think that it's important to revisit the foundational principles surrounding the EC's mandate.
Yeah, we have just some 2 minutes. Just some 2 minutes.
Right, that's the thing. So the EC is a referee, and as a referee, I think there must be perceptual confidence in the EC's work. The whole issue of consultations and the whole issue of confidence building and bringing people on board is just to reinforce that perceptual confidence. So the EC maybe have power or authority in a lot of the things that it's doing, and there's no doubt about that. And I have a great deal of respect for the leadership of the EC. I think it's imperative that the EC harnesses the consultative process and brings on board all these actors so that there's confidence in the process. I think that the disputations do not help or aid in the perceived neutrality and the referee character of the EC, and that's the need. So I think that there's a need for further consultations. I would hope that they would open up some of these consultations because of everything that's ongoing in the circumstances of the time.
Okay, thank you very much. But before we close, I'd like to make this. Last week, Newsfile examined reasons for and against the Public University Bill 2020. We hosted mainly university professors and asked why they were unanimously opposed to it. And we made references to memoranda submitted by the UTAG, the CDD, and the Ghana Academy of Arts and Sciences, who were all largely demanding its withdrawal for many reasons, including that it was retrogressive. One of our guests, Professor George K.T. Odro, former Vice Chancellor and current Dean, School of Educational Development and Outreach, University of Cape Coast, in his submissions made the following statements. I read. He said, among others, that currently the Institute of Educational Planning and Administration has been upgraded to a Category 2 status by UNESCO, and there is someone who has been actively involved in this, that person was to be granted a position at that place. The Vice Chancellor couldn't effect that because the Minister of Education is alleged to have made a pronouncement against the appointment of that person. The Education Minister, Dr. Matthew Opoku Prempeh, isn't pleased by this. He says, while the statement is, quote, vague and speculative, it is untrue and unfair to him. Professor Odro was clear he was repeating an allegation. I should have required him to substantiate or recant it, however vague or speculative. The statement is accordingly retracted, and I apologize to NAPO. A while ago, I received separate statement from the UCC and Professor Odro himself. The university denies his allegation, and he also states that he does not consider the allegation as credible enough to use as evidence. He therefore regrets any inconvenience the presentation error, he calls it presentation error, might have caused the Vice Chancellor and the University of Cape Coast or any party. So I needed to say that. But how nice it would have been if the minister had made himself available for that important discussion last week with the stakeholders. I suppose on that note, we draw the curtains on this edition of Newsfile, but I still have a couple of couple of minutes to spend, so let me read a couple of your messages. This one says from Kweku Enchibu Esiako, it says, I would interpret constitutional provision in the context of COVID-19 related disenfranchisement to include any law, including executive instruments that are not inconsistent with the Constitution. Therefore, if the EI is able to legally restrict other constitutional rights of a citizen by reason of public health, then the same restrictions could legally apply to the right to register to vote. That's my humble and learned view. All right, thank you for your view. A couple more of the messages that you have sent in, and then we'll take a break. Charles Rekubrobe, you know him as Tarzan. He says that, well, okay, I have to close here, but he has issues with the manner he says is hiding things that are being done and not made public so that everybody can enjoy it, like Bright Simmons is talking about. My guests have been Bright Simmons, Honorary Vice President of Imani Africa, Mr. Kofi Abochi is Dean of the UPSA School of Law. Earlier, we had Dr. Bempa Tando of the Ghana Education Service. Have a good afternoon. My name is Samson Ladi Anyanini.